Good morning and welcome to Lattes and Legacies, and Happy New Year 2019. I'm Steve Worrall, Marietta estate planning and elder law attorney at Georgia Estate Plan Worrall Law. Today I'm going to be discussing in fairly general and broad terms financial powers of attorney, which are an important part of a complete estate plan. Now remember, estate planning is not just about what happens to you when you die, or your stuff when you die. It's about what happens to you and your stuff while you're still alive, but incapacitated, unable to take care of yourself. So a power of attorney comes into play at that point. Now, what is a power of attorney? A power of attorney is a legal document in which one person, called the agent, is given authority to act and transact business on behalf of another person called the principal. Now, today we're not going to be discussing a healthcare power of attorney, which is where you appoint a healthcare agent to make your healthcare choices if you can't communicate your wishes at a particular time. We'll do that in a future episode. But today we're talking about financial powers of attorney. So why have a power of attorney? Well, a power of attorney is an important document to have if you cannot, either as a result of convenience or necessity, transact business for yourself. Let's say you're living in another state and you're closing on a real estate transaction in the state of Georgia. You want to have a power of attorney so that someone can appear at the closing and act on your behalf and sign the documents necessary to complete the transaction. Now, in a more typical situation, you want to have someone that, if you are incapacitated, who can take care of you and your things while you're sick and incapacitated. The parties involved in the power of attorney are basically three. There is the creator of the power of the attorney, or the grantor, sometimes called the principal. There is the person who's given the authority to act, that's called the agent, or sometimes in Georgia we have historically called that person the attorney in fact. And then, of course, there are the third parties who are called upon to accept the power of attorney and allow the agent to act on behalf of the principal. So when and where do we use the power of attorney? Well, I gave you the example a moment ago of the out-of-state real estate transactions. But if you were incapacitated, if you were sick, in a coma, or had dementia or Alzheimer's, and you could not take care of yourself, this is an important document that allows someone to act on your behalf while you're in that condition. So there are different kinds of powers of attorney. There is a general power of attorney or a limited power of attorney. The general power of attorney gives a very broad set of powers to your agent to act on your behalf. A limited power of attorney is, by its definition, limited, either in terms of scope as to the authority that you're given the agent. The real estate transaction I mentioned earlier, you can say that the agent is only empowered to sign those contracts that are related to the real estate. Or it can be limited in time, that it's only good for a certain period of time while you're traveling in Europe, for example, and you want your agent to be able to act on your behalf while you're traveling. Most powers of attorney these days are durable. Now, in the past, powers of attorney were often not durable. What that means is that they outlast your incapacity. In the past, a power of attorney that you created while you had capacity would terminate if you lost that capacity. But that's exactly the reason you want to have a power of attorney. So that does make a lot of sense. So the law has been changed to allow for more durable powers of attorney that will outlast you becoming incapacitated. Now, these powers of attorney can either be immediate, which means your agent has the authority to act for you right now. You give him all the authority that he needs or she needs to take care of you and your things and transact business on your behalf right now. Or it comes into existence in the future. That's called a springing power. It springs into existence. In other words, there's a condition that has to be satisfied. And that condition is typically your incapacity. And how is that determined? Well, usually it's either by one doctor or two doctors certifying that you are in this condition, that you are not able to take care of yourself or your property, that you have some sort of impairment that prevents you from doing so, and that someone else then can go forward and act on your behalf under the terms of the power of attorney that you've created. So how do we create a power of attorney? Well, it has to be in writing, and it has to be created at a time that you have capacity. It needs to be signed by you as the principal, and it clearly states the powers that you're giving to your agent. It needs to be signed by you. It needs to be signed by one or more witnesses, and it also needs to be signed by a notary public. Now, all these signings have to be done in the presence of each other at the same time. And then there's also, this does not have to be done at the same time, the acceptance by the agent. The agent has to indicate that they are willing to act upon upon your business according to the terms that you've given them. And that this also certifies that all conditions have occurred before the agent is allowed to act. Now, the state has statutory power of attorney forms. In Georgia, we created the most recent one in July of 2017. Now, this document is in a lot of ways worse than the old documents. The old documents had a very clear definition of all the powers that you're giving to your agent. They were spelled out in broad paragraph form. I have, giving my agent the power to deal with my real estate. That means he has the power to buy, to sell, to rent, to lease, to collect the rents, to basically do everything we need him to do in relation to real estate. Well, the new power of attorney form in Georgia just has little blanks for certain types of transactions: real estate, banking, personal property, and you initial these to indicate that you're giving these authorities to your agent. So it's not really clear exactly what powers that you're giving other than these broad general categories. So it's very non-specific. The thing that I do like about the power of attorney under the current statute, though, is that banks and other third parties are required by the law to accept it if the form is in the statutory power of attorney form, or if it's very substantially similar to it. And the other thing that I like about the law is that you're allowed to attach an exhibit or set of special instructions to flesh out those powers that you're giving your agent, so that those initial blanks are not just left there to the imagination as to what your agent is allowed to do, but you're spelling out in very detailed paragraph form what those powers are. Now, we'll do a deeper dive into the Georgia statutory power of attorney next time. But if you have any questions about that, please let me know in the comments, and I'll be happy to make sure that we address those next time. Now, you can have a sole agent, or you can have multiple agents. I generally don't recommend having multiple agents. It's kind of like having two dogs pulling on the bone at the same time. That's not a real good choice in many cases. And in some cases, that's exactly what the principal wants, though, and they have good reasons for doing that. Typically, though, you're going to have a succession or a batting order of agents that can act on your behalf. This is my first agent. If he's not available or willing to do it, then we're going to go to the second agent. As long as I've got someone in the batting order, then my power of attorney is still valid because we've got someone to carry out those instructions. Now, how do you end a power of attorney? How do you terminate it? Well, you can revoke it by destroying it. You can tear it up. Of course, if you've given copies to your agent and they've given copies to third parties, then that may not be enough. You can also give a written revocation to your agent and deliver that revocation to any third parties that he or she might have given the power of attorney to. It's sometimes difficult to know who all those people are that he's given that power of attorney to, though. And the agent can simply resign, and if there's no more agents in line in the batting order, the power of attorney ends. And it can end on its own terms if it's a limited power of attorney. Also, and this is very important, the power of attorney ends when the principal dies. This is a very common question we have when people call our office, that I've got my mom's power of attorney and she's just passed away. I need to sell her house. Well, you can't act under the power of attorney anymore. Now we're into the realm of probate. You're going to have to go through the probate process. Is there a will? Is there not a will? And so forth. Now, two important things to remember about powers of attorney. As I said, they end when you die, and they cannot be created when the principal is already incapacitated. If they are incapacitated, they don't have the legal authority to create a power of attorney. And this brings to mind that the most important purpose of the power of attorney is that it's kind of a bridge to a guardianship or conservatorship. It's a very important part of a power of attorney to indicate what your choice is, who your choice is to serve in the role of conservator. That is the person who's going to manage your assets if you can't, and if a court has to appoint someone to take care of you. The power of attorney lasts up until the time that conservatorship is put in place, but at least someone is able to take care of your business while that process is going on, because it's not an immediate process. Now, if you don't have a power of attorney and you become incapacitated, the only path for taking care of you and your stuff is a guardianship and conservatorship filed in the probate court. This is another frequent call that we get. I need a power of attorney for my mom. She's in a memory care facility and I've got to take care of her stuff. well, we have to tell that caller that at that point it's probably too late for her to create a power of attorney, and that they're going to have to look at pursuing a guardianship or conservatorship to get control over their mom's assets. If you have any questions about this, please let me know. I will be doing. I hope that this has been a very general overview, I realize, but we're going to get into a deeper dive next time on the Georgia statutory power. And if you have any questions in the meantime, please feel free to put them in the comments below this post, or to private message me here on Facebook, or to email me at steve@georgiaestateplan.com. If you have any other questions or topics that you'd like me to cover, same thing. Comments, direct message, email. Best ways to get in touch with me. If you need our help, though, for creating a power of attorney or to create a complete estate plan for you or your family, please call us at 770-425-6060 or email me at steve@georgiaestateplan.com. Thanks for joining us today.